Today we are going to talk about court cases. You can't do any legal writing without cases, but the good news is that the basic form you learned in your first year classes will generally stay the same. Except for a few changes in the use of italics, they will also be the same in your footnotes in academic writing. There are a few ways you can improve your basic case citations, however, and we're going to talk about some of the details you can include to improve the accuracy and persuasiveness of your citations. Remember that the basic case citation includes the party names, then the reporter information, pin site, and the year. Information in parentheticals, such as whether the case was heard en banc or per curiam, as well as the prior and subsequent history of the case, can add to your reader's understanding of the importance of the case within the larger body of common law on your topic. The basic format of party names is easy if you have two individuals in a suit. You just use the last name of the first listed party on each side. It gets a little more complicated if the parties are some other form of entity. Take a look at Rules 10.2.1 and 2.2. It seems complicated, but generally you want to use only common abbreviations in the text of your memo or brief, then use more abbreviations in the actual citations. The goal here is readability. You want to keep your citation sentences and clauses short so that they don't detract too much from your writing. There are 8 listed abbreviations that you can use for names of entities, such as CO for company. Make sure you check Rule 10.2.1 for the list before you start abbreviating. Luckily, all of the information you need for a citation will be right there in the reporter. If you are having trouble sorting out what page number you are on from all of the stars in an online version of your case, try downloading the case reporter image from Westlaw to look at the reporter itself, or just grab a physical copy of the reporter off of the shelf. If you look in the top left-hand corner of your case page in Westlaw, many times you'll see a link to download a PDF. If it's a reported case, then you can look at the physical copy of West's reporter and have the page numbers right in front of you. Whether you can cite to an unreported or unpublished case in a court document will depend on the court that you are in. Unreported federal cases often end up in the federal appendix, which can be cited to as though it were the reporter. When you get into state cases, however, you may have something like a Westlaw citation instead. Keep in mind that you must cite to the case docket number followed by the unique number your commercial database assigned to the case, whether it's Westlaw or Lexis or Bloomberg. You will often see short explanatory phrases in parentheses after a case. A variety of different pieces of information can be included with a case, with the goal of helping the accuracy of your citation. If you are citing to a concurring or dissenting opinion, you should include that in a parenthetical. If the opinion was published per curiam, meaning it was published by the court as a whole rather than by a particular judge, or issued by a court sitting en banc, meaning the entire bench heard the case instead of a select panel, you'll want to indicate that as well. This ties back to the persuasiveness of your writing. If a court decided to sit en banc because this was a matter of importance or an especially complex case, then a holding in your favor will have more weight and may be more persuasive to your reader. The use of quoting or citing within a parenthetical is often confusing. Just keep it simple. If you are citing to a case often, and at one point it cites to language from another case, you'll want to indicate that in the citation. If the only reason you are citing to a particular case is because it quotes language from another, you may want to consider just citing to the original case itself. Prior and subsequent history is another place that confuses legal writers. Just keep in mind what you are doing with your citation. If the history of the case in a lower or higher court is relevant or surprising, then you need to include it. Often it will be persuasive, such as if a higher court affirmed without an opinion instead of just denying an appeal. If a case is against you and it was overturned on appeal, then make sure you say so in your citation. The goal with all parenthetical information is to make sure there are no surprises for your reader when they do further reading. If there is something that you didn't tell them that your opposing counsel did, or if they discover it on their own, then you'll lose credibility as a legal writer. Be upfront about the pedigree of the cases you are citing to. If you have more than one parenthetical, then the Blue Book has a specific order to put them in. Under Rule 10.6.3, list any indications of the weight of authority first, then any quoting or citing information, followed by any explanatory phrases, such as a synopsis of the case or your prior or subsequent history. If you come across something that doesn't quite fit within these categories, check out Rule 1.5b. It has an example of all the potential parenthetical information you can have in a citation listed in order. Remember that the Blue Book is not the only source you need to use. The Florida Style Manual and the Florida Rules of Appellate Procedure both govern how you cite to cases in Florida. Before you begin work in a firm or a government agency, look up court rules where you will be filing on the court's website. For example, Rule 9.800 has a different citation format than the Blue Book when it comes to Florida District Courts of Appeal. In the Blue Book, there's no way to indicate the number of the district court you're citing to, but in Florida, you shorten the citation to just DCA, but you need to put whether it's the first or second or third, and so on. You should become comfortable with case citations because they are by far the most common resource you will come across in your legal career. Next week, we are going to cover administrative and legislative materials, which aren't covered much in your first-year classes, but will come up often in legal practice.